Retirement and maintenance in an Illinois divorce. Maintenance, formerly known as alimony, in Illinois, is a way to further ensure an equitable division of finances between two spouses who have unequal incomes. One spouse has relied on the other spouse for regular financial support. The Illinois legislature states the supporting spouse should continue to support their ex-spouse in a definite amount for a period of definite time. Ordering maintenance for a defined duration of time makes sense if the supporting spouse is going to be working for the entirety of that defined duration of time. But, if the supporting spouse is likely to retire during that defined duration, certain considerations must be taken. How does maintenance normally get calculated in an Illinois divorce? Maintenance is typically awarded on a guidelines basis. Guidelines maintenance shall be calculated by taking 33.33% of the payer's net annual income minus 25% of the payee's net annual income. 750 ILCS 5/504, B1, 1a. This is followed by a big caveat that limits the amount that payee can receive under a guidelines basis. The amount calculated as maintenance, however, when added to the net income of the payee, shall not result in the payee receiving an amount that is in excess of 40% of the combined net income of the parties. 750 ILCS 5/504, B1, 1a. Guidelines maintenance then lasts for a specific amount of time based on how long you were married. What if you are going to retire soon and you are getting an Illinois divorce? If you are close to retirement and considering divorce, you are likely to have been married to your spouse for a long time. Thus, the duration of your alimony can be expected to be almost equally as long as the marriage. You're not likely to work that long. If your Illinois divorce is not yet finalized but your retirement is on the horizon, then you should alert your spouse, the opposing counsel and your divorce judge to the factors they must consider when setting a maintenance amount and duration of the maintenance payments. Before ordering guideline maintenance, he court shall first make a finding as to whether a maintenance award is appropriate, after consideration of all relevant factors. 750 ILCS 5/504, a. Several of the factors the court must consider before awarding maintenance in an Illinois divorce are directly impacted by a pending retirement. While these factors will probably not impact the amount of maintenance in a pending divorce, the duration of maintenance can be reserved if retirement is truly looming. Illinois courts must consider future income as well as current income when determining maintenance. Retirement can likely be listed as a contemplated substantial change in circumstances which will allow for a modification of maintenance at the time of retirement. What if I am retiring after my Illinois divorce is final? Maintenance can always be modified after an Illinois divorce unless the parties agreed that the maintenance will be non-modifiable. Retirement is a voluntary change in employment which Illinois courts usually don't look fondly upon for maintenance modification purposes. But, sooner or later, everyone gets to retire. Employment changes that are voluntary must be made in good faith and not prompted by a desire to avoid maintenance obligations. In re Marriage of Waldschmidt, 608 Nebraska 2D 1299 Ill. Appellate Court, 4th Dist. 1993. Good faith retirements are largely determined by the motivation of the retiree. So, complaints of the current work and the imaginings of retired bliss are sufficient to establish a good faith basis for retirement. Of course, it is probably better to elaborate on why retirement is necessary due to age and health. However, not all retirements are really retirements. Some retirements don't even warrant a reduction in maintenance. Litigants have a right, at some point, to retire or to substantially reduce his working hours. But this will not necessarily justify a reduction or a termination in maintenance. In re Marriage of Waller, 625 Nebraska 2D 363 Ill. Appellate Court, 1st Dist. 6th Div. 1993. Retirement assets and maintenance after an Illinois divorce. Most retired people are retiring because they have enough money to live off of without working. So, in almost every motion to modify maintenance during retirement will consider the assets of the parties. When determining maintenance amounts and duration, Illinois divorce courts will consider he property, including retirement benefits, awarded to each party under the judgment of dissolution of marriage, judgment of legal separation, or judgment of declaration of invalidity of marriage and the present status of the property, 750 ILCS 510, A5, 6. These retirement funds should be generating income, and maintenance is calculated based on income in Illinois. In Illinois, income from assets that have already been divided in a divorce can be used to calculate child support owed, but income from assets already divided cannot be used to calculate maintenance. The theory is that money in a retirement account has already been earned once, so withdrawing that money, while it creates a taxable event, is not truly current income. Furthermore, these assets were already divided in the divorce. So, any further allocation of the assets or their income constitutes an amendment to the property division, which is not allowed. So, if one party has waived an interest in an asset during the divorce, simply by awarding the asset to the other party, that party cannot ask for any part of the income proceeds from that asset for the purposes of maintenance. If a party has been awarded significant assets in an Illinois divorce, they are also not required to sell those assets and live off those assets in lieu of maintenance. Social Security and maintenance in an Illinois divorce case. Sometimes, an ex-spouse can get more money from the government than they could get from a maintenance payment. Even if that is the case, it is no excuse to reduce alimony. An Illinois court cannot take into account a party's eligibility for public assistance when determining whether maintenance should be terminated. In Re Marriage of Anderson, 951 Nebraska 2D 524 Ill. Appellate Court, 1st Dist. 5th Div. 2011. So, don't expect to modify your maintenance just because your spouse is now collecting Social Security benefits. If you're retiring, or your spouse is retiring, and there is any kind of maintenance being paid through an Illinois court order, you need to know the law and how to apply the law. Contact the Law Office of Russell D. Knight today at 773-334-6311 to schedule a free consultation with an experienced Chicago divorce lawyer.